The broadcast is now starting. All attendees are in listen-only mode.
Hi everyone, it's James from Community Legal Centres Queensland here. Welcome to another one of our webinars. For those that have played before, can I get you to press the button that looks like a hand on your control panel so that I can just check that you can hear and see us, or me, okay at this stage. Terrific, lots of hands going up, so we'll assume that you can follow what's happening. Good morning, welcome. I'll begin the session today by acknowledging the traditional owners of the lands on which we're gathered. So I acknowledge the Turrbal and the Yagara people here at our office. We're in Brisbane here, so I acknowledge the Turrbal and the Yagara people as the traditional owners of the lands on which we are. We acknowledge First Australians across the country because we've got people tuning in, I think, from every state and territory, which goes to show just how important this issue of small and negative property pools can be for community legal centre lawyers. Before I hand over to our presenters, a couple of housekeeping things. We're having to have a recording of this presentation made available to you, technology willing, so we'll make that available. You should also be able to access two handouts on your control panel there. These are memos that have been prepared by Jane Browers and Erin Morris from the University of Queensland, who have been providing some help to Jacoba, our speaker, in preparing for the presentation. And so we thank Jane and Erin, who've also been lassoed into presenting a little bit of today's webinar as well, which is fantastic. There are a couple of ways that you can ask questions, and we do encourage you to ask questions as this webinar goes on. Sometimes the technology can be a bit clunky in terms of those questions, but we're really keen to make this as conversational as we can. Two ways that you can ask questions. You can press that button that looks like a hand on the control panel of your GoToWebinar system there. I'll see something that looks like a hand pop up on our screen here. We'll be able to unmute your microphone and you'll be able to ask Jacoba a question directly. The other way that you can ask a question is to type something into the questions box. I'll paraphrase that and put it to Jacoba here in the room, and we'll work it out there. That's the housekeeping stuff. Let's get into it. So as we said in the promotions for this, property settlement can absolutely be some of the bread and butter family law work that community legal centres do. About 35% of all of the work of Queensland's community legal centres is in the area of family law, and it's becoming quite difficult and sometimes quite tricky for community lawyers and generalist community lawyers to understand some of the intricacies of those disputes that relate to property settlement where there's a small or negative property pool. It can be vitally important, and sometimes we fall into the trap of thinking that if there's property there to be settled, it probably isn't core community legal centre work because people have some assets and can share it. Of course, it's much more complicated than that. When we're talking about where an asset pool is only superannuation, when we're talking about quite small asset pools, we're talking about debt between separating parties. It can be the difference between someone restarting and rebuilding a life with bankruptcy or with the capacity to get back on their feet. So this is absolutely a core part of the family law practice of community legal centres. Really grateful to Dr. Jacoba Brasch QC for presenting the webinar today. Many of you will know Jacoba. She was called to the bar in 2000. Before that, she worked in a range of law-related government roles. Jacoba has a PhD from the University of New South Wales, a Master's as a Fulbright Scholar from New York University. Took Silk last year, Jacoba? 14, I stand corrected, sorry. And is really a huge supporter of community legal centres work. Recently appointed to the Australian Bar Association to lead the Australian Bar Association's Access to Justice Committee, and a family lawyer of impeccable qualifications. So really grateful to have Jacoba to present to us today. And so I'll hand over now. Just bear with me as we swing our screen around.
Hello everyone. Thank you for that kind introduction, James. I'm joined today, I'm delighted to be joined by two law students, although one has just graduated. University of Queensland offers a fantastic pro bono legal service, and I was delighted when James suggested that UQ work with me And the product of that is the two excellent memos that you have. I'm joined here that you can't see them yet, but I'll put them in screen at the appropriate time. They're both going red. Erin Morris and Jane Browers. You've just graduated, Erin, haven't you? And Jane, it's her last semester. Now, Erin and Jane produced, for what was originally going to be my research purposes, two excellent memos, a memo each that give a very recent snapshot of cases in this frankly difficult area. And so good were their memos that unbeknownst to them, I contacted the Director of UQ Pro Bono Centre and said credit where credit is due. And so you'll see, oh, they're both really going red now. So you have these memos that James has linked to you. They are appropriately attributed to Erin and Jane, and I hope they'll be of some use to you. I certainly found them. Ironically, on Monday, I did a small pools matter as an arbitrator, and I'll talk about that in a little bit, the role where arbitration may play, and their memos I found useful. But so good was their work that I invited them not only to come along, but yesterday afternoon I gave them the heads up that when it comes to the discrete areas they looked at, I'll be switching the computer around and they can talk to the themes that they've developed in this in their research. Small pools are, I think, in property proceedings, the hardest proceedings, and I'm not telling you people anything you don't know. As I said on Monday, I had a small pool matter. The pool was $200,000. The parties were 5% apart. The wife wanted 60%, the husband 50%, said she could have 55%. That's $10,000. Now, there were other aspects to that that warranted it being arbitrated, but I am certainly alert to the very real concept and principle that every dollar counts and every percent can make a difference. That being said, we of course as lawyers work in the world of principle, legal principle. But the other thing I have discovered over 16 years of doing family law at the bar, I also did family law when I was in New York and had involvement prior to that, spending some time in New York doing a master's. The other thing I've discovered though, legal principles are expensive. They are an ideal, they are something to guide us, but the message that I would hope you can take home from this session is that small pools require pragmatism. Of course, going to court is expensive. It's expensive for legal fees if your clients are fortunate enough to be able to afford that. But it's expensive in time, in stress, in what I call lifestyle factors, and I don't mean to be diminishing by that, but if you're going to spend your whole day waiting at a registry to file some documents, or your client is, most of them probably have better things to do with their time and their lives. It's the photocopying of documents, the correspondence, nothing worse than when a person is self-representing or getting some assistance from any of you people, and there's a well-resourced lawyer on the other side who bombards with correspondence after correspondence. So small pools require pragmatism. Of course we have to work within legal principle, but as the memos that Erin and Jane have produced, there are certainly sufficient cases where the judges say, after you've waited 2 or 3 years to have your matter heard, despairing that the dispute remained within the court. Now, I mentioned Monday I did an arbitration. It's the brave new world in family law. Rules, the regulations and the rules have recently been amended to provide certainly better coverage, if you like, or better ground rules. Keep it in mind. It's something to have a conversation, I think, to start including in conversations with clients. Mediation, at least in Queensland, private mediation and conciliation conferences are very popular. I'm aware that in New South Wales and Victoria that the private mediation isn't as popular as perhaps it's taken off here. We have Federal Circuit Court Judge Bowman to thank for the popularity of mediation here. But the arbitration model is interesting. Now, some of you no doubt are thinking, heavens, I hate to think what the QC, i.e. me, charged to arbitrate. I can tell you what I charged wasn't insignificant, but when the parties were were told on their first return at court they wouldn't get a trial for 2 to 3 years, and even though they were only 5% apart, $10,000, there was a business, a family business that was valued at nil, but it was an income stream, and they each wanted to keep it. So they took the pragmatic view that they'd agree to an arbitration. We had the arbitration on Monday, and I handed down the award yesterday afternoon. So if access to justice also includes speed or getting a resolution, because these two were, the prospect of the two of them remaining in the business together, as the court had allowed them, for the next 2 to 3 years, and who knows when they would have got a judgment after that, was something that they decided pragmatically that they would spend a bit of money to get on with their lives and get the result done. The alternative, of course, is waiting in court, waiting. We've all had the experience, no matter how hard our Federal Circuit Court judges may work, they are simply overrun. So I'd invite you to think about the idea of arbitration. I am aware that there are a number of solicitors and a couple of ex-judges who are considering a model that they will charge pursuant to what the party's financial status is. So don't think it's just the province of the silks or, people like me, but we'll be developing, and part of my role as the Access to Justice Committee of the ABA is to try and get this information out, which solicitors are prepared to charge a lesser rate, experienced family law solicitors to charge a lesser rate to arbitrate something that really cannot go to court because of the time involved, the stress involved, of course, and the money it may otherwise cost. Now, small pools. The process and the principles are, of course, the same. But as I said, no surprise many of you are on the line because I think they're the hardest of property cases. It is easy when you've got multi-million dollars to say to one party, just flick another $1 million and it'll all go away. Oh, to be in such a world. But of course, that's not the world that many of us work in. But therefore, even though the principles are the same, there really needs to be a pragmatism developed to the small pools. I get very sad when I see matters in court, when you're sitting waiting for your matter to get on, and really the dispute comes down to very little by way of property, but a chattels dispute. Items that the parties hold dear that have actually, in our world, very little monetary value. I find those matters very sad, and I'm going to talk at the end, after I've thrown over to Erin and Jane, I'm going to talk about the importance of reality testing as well. I think a critical role for lawyers is to help clients understand the process, but also understand the reality. I've seen many a client or sat in the back of court and watched many a case where really it was more about revenge, or it was more about proving that I'm right and the other side's wrong. That's a very time-consuming, emotional roller coaster to be on. But the steps are the same. Post the fabulous High Court Stanford era, we kind of have 5 steps now, really. But don't be scared by Stanford. I think it's fair to say when the High Court dabbles in family law, and I don't mean that disrespectfully to the High Court, I simply mean that very few family law matters can get through the Justices Act and the Judiciary Act to find their way in the High Court. I go back to the relocation case, MRR, and I look at Stanford, and there was a great flurry of activity after these decisions were handed down, and we thought it was a whole brave new world. Relocations have gone back to difficult cases that they are, and Stanford, much flurry and activity when it was handed down, but in most cases it won't matter. And I would urge you all not to get terribly caught up in, the conflating this and that and all the things that the High Court said. In most cases, by reason of joint ownership of property and the voluntary decision to end the relationship, it will be plainly just and proper for there to be an adjustment. It's useful, now let me pause here because I want to develop this a little sort of organically, if you like. I will do a list of cases and give that to Jane that I'm going to, James, sorry, that I end up speaking about today. I'll send that through this afternoon for circulation. But remember, Stanford was really an unusual set of circumstances, and I think it's fair to say that it was about adult children from two, earlier relationships trying to affect some estate planning is really what it was about. But don't forget paragraph 43, and I'll include this in my notes later. Really, Stanford just says the bare fact of separation, and in that case it was involuntary. The bare fact of separation, when involuntary, does not necessarily mean it's just and equitable for there to be a property settlement. Does not permit a court to disregard the rights and the interests of the parties to do what the court thinks is fair and just. So it's useful to remember that touchstone at paragraph 43 of the High Court decision, the bare fact of separation, and there it was involuntary. But the paragraph before that, paragraph 42, surprise, surprise, being the paragraph coming before 43, is really where we will find most of our work. And there the High Court, the plurality, said in many cases it will be just and equitable if there be a property settlement. That being the result of the way the parties had common use of property, they've voluntarily decided to separate, and therefore that common use of property will not continue. So don't get terribly caught in Stanford. That being said, I think it's useful to keep Stanford in mind for short relationships. Whether the asset pool is big or large really doesn't matter, but let's concentrate on the short relationships where the pool is small and where one party has bought all of the property to that short relationship. And if there are no children, we know the court's emphasis will be, first of all, on the Stanford kind of approach. Should there even be a settlement? You look at the legal and beneficial interests of the parties. Should there even be a settlement on the Stanford principle? So that's where I think Stanford can, and in the case law has had some application, short relationships, no children, where one party unequivocally brought everything to all of the assets to the relationship. It surprises me that we don't see Stanford being raised in those shorter relationships where one party bought everything, but at least for listeners today, keep it in mind, not for the wider proposition or the scary Stanford, is there even going to be an adjustment, but simply on those small pools, short relationships, no children. Now, the next step, of course, so let's put Stanford aside and work on the basis that in most cases you'll get over the hurdle. I think you'll know it when you see it. The few I've actually run and run successfully, you look at them and you go, well, this is a Stanford case, there should be no adjustment. They seem rather obvious when you come across them. So the pool, now you have the benefit of a memo from Erin, and I'll ask her to speak to the theme she discovered in a minute. She's looking very nervous now, but it'll be fine. The pool really shouldn't be that difficult in a lot of circumstances. get the house valued, or before that, see if the parties can agree to simply work with an appraisal. Or if the reality is the house has to be sold, then that will determine your value. Cars, use Redbook. I'm not telling you anything that you don't already know. Be careful about add-backs, and I'm going to come to add-backs after Erin's spoken. I'm going to talk about add-backs and partial property settlements, and perhaps relocate. That's one of the lots of reality testing that we need to do with clients. Of course, the general position for the decision maker, the judge under section 79 or the de facto equivalent, is to assess the party's property at the time of final hearing or close enough to it, or the mediation, or whenever you are trying to reach a solution, or even in the early days when the client first sees you. The exceptions, of course, to that is potentially credit card debt. What parties have spent and credit cards post-separation can quite often be excluded from the pool. Otherwise, one party is subsidising the other party's lifestyle. It would be certainly, though, appropriate to argue for credit card debt at the date of separation. Certainly be argued that go into the pool. But add-backs and part property settlements are matters that I'll touch on, but I want to now turn over to Erin, who can develop the themes that she discovered on small asset pools and ascertaining the pool. Look, that's Jane.
Good morning. I'd like to firstly thank Jacoba and James for having me and for including me in this. So as Jacoba said, I looked at ascertaining the pool where the assets are minimal. I found that the resources on this and discussion in cases is relatively scarce because, as Jacoba's already alluded to, a lot of times the pool's already agreed to and it's the allocation that the parties are at court looking for. Secondly, it might also be that the judge has determined that the only major assets is the home or the superannuation the parties have, and they determined that the smaller assets are more unnecessary to really properly characterise. Thirdly, there's also times when assets are in dispute, but a conclusion was reached with limited reference to the size of the pool itself. Where I found that the size of the pool was referenced was in relation to the contributions the parties made and the Section 75(2) factors, which Jane will go on to discuss later. Factors such as assistance given by parents to the parties throughout the relationship, which we initially thought may be a subject of argument in terms of being included in the pool, was actually, I found in the cases discussed more in terms of the contributions of the parties. So in cases such as Tomlin and Nielsen and GS and TS, it was discussed there that these contributions paid as made, whether it be living rent-free in the parent's home, was actually taken into account in terms of the parties' contributions. Inheritances as well, which we thought might be a bit of a tricky thing to include in the pool, was also taken into account more later on in terms of whether an award was just and equitable in the end. Also in terms of superannuation, whether to include that. Courts discussed, and as Jacoba said, in delivering a more practical outcome. They discussed then whether the size of the pool itself, whether there was enough in it to actually split and to recognise the parties' contributions and their needs. They talked then about needing to include inheritances and superannuation in order to there be enough within the pool to actually account for these contributions and needs. So in saying that, superannuation and its inclusion was probably the largest area of discussion within these cases. In most cases, it was deemed an asset within the pool and was discussed by judges, and whether it be a splitting order was given or not. There was a series of cases though where it was seen that the superannuation itself was of such a minor value that it wasn't worthy of an order too. But as I said, it was discussed in a lot of cases more in terms of the similar vein as inheritances, in terms of whether it's just and equitable, the final outcome. And it was giving enough worth to the contributions of the parties and their needs in the future.
Thank you. Back to me. Now, can I just, as useful and as much as we as lawyers love memos with facts and everything in them, don't forget that the memos that Erin and Jane have produced, they're primarily fact cases. I spend a lot of time in the full court hearing particularly Justice Murphy saying when someone will quote a case, but that's a fact case. So even though the facts here are of interest, don't necessarily assume that because the facts are similar to something you've got that necessarily the result will be the same. What these memos do for me in a practical sense, or what I'd suggest they might assist you with, is obviously parameters, but we all know different judges have different views. For every case that you could find, and of course the resources are small here, where, for example, the chattels were excluded from the pool, you'll find cases where they're included. And thus the uncertainty we have. But that's part of the reality testing that I think it's incumbent we do as lawyers with our clients, no matter the size of the pool. And on Erin's memo, if I could just, page 2 when you see it, right down the bottom there's a reference to a 1992 case called Bonici, B-O-N-N-I-C-I. It's an interesting case, that one. It stands for the proposition that a post-separation inheritance, an inheritance very late in a relationship, should be excluded. It has never been expressly overturned, but there have been some suggestions in more recent full court decisions that it may not be the best approach to follow. We all know what Coghlan says, those more recent authorities, about put it all in the pool. So just a little note, I quote when it suits me Bonici from time to time, but don't necessarily expect that you'll get home on that one. The idea of a negative pool is an interesting one as well, and in the note that I'll send back to James to circulate to you will be 2 cases. One is a decision of the now back at the bar but then Federal Magistrate Wilson, single federal magistrate as he was then, decision where His Honour determined a negative pool was not justiciable. I have a problem with that because sometimes the only thing people leave with is debt. That case hasn't been picked up, but I'll send that, and in fact I'll send the decision because it's a hard one. It's not on Ofstley. I'll send the actual decision as well. I thought that idea of a negative pool, keeping in mind section 79 and the de facto equivalent talks about the assets and liabilities of the parties, the financial resources. I thought the idea of a negative pool not being justiciable was put to bed until my horror. A couple of days ago I read a very recent decision of Justice Aldridge in the Family Court in Sydney. His Honour spends most of his life on the full court, but he was doing a trial where there was a throwaway line in there that he determined that negative items were not an asset and therefore could not be divided. Thankfully though, the majority of the authorities is that even if the only asset, if you like, is a negative, it still needs to be divided. The other matters I think that loom large often in small pools are the idea of add-backs and how do we locate partial property settlements. This is where the pragmatism, particularly with add-backs, really needs to come in. Are you going to suggest to your client that it's worth his or her while spending the next 18 months, 2 years, 3 years in litigation when the one thing that keeps the parties apart from settlement is how, for example, a partial property settlement of $20,000 was spent, or how post-separation credit card expenditure was spent. Ultimately, of course, a matter for the client and a decision for the client, but again, I'll come back to the reality testing. Add-backs was, of course, part of the whole Stanford, flurry, as I call it, the flurry of activity. There was, of course, then a decision of Justice Murphy, Watson and Ling, where we all thought, oh, maybe add-backs don't exist. I think it's pretty clear now that the justice of the case, if the justice of the case requires adding back, and I'm going to assume you all understand the concept of notional property, the adding back, if the justice requires it, the court will be amenable to it. I will send for you a fairly recent decision of the full court called VAS, V-A-S-S, and VAS of 2015. There, a Melbourne counterpart of mine, a Silk, argued that post-Stanford legal fees could no longer be added back. That argument got very short shrift. So legal fees certainly can be added back post-separate, or where joint money has been used. But with the premature distribution type of add back, that Townsend that has long been in our case law, or the reckless, wanton and negligent add back, the Kowali type of add back, can I suggest if the pool is small, and that's what we're talking about, there really needs to be a pragmatism, particularly when the state of the law for those two areas of add-backs is perhaps not as uncertain as it was immediately after Stanford, but I'm seeing in the authorities there's really got to be, one of the phrases used a number of times in the cases, there's got to be an affront to justice. And then there's a difference of opinions. I read one case when I was preparing for this last weekend where money spent for a modest car for the adult daughter of an earlier relationship was added back, but another where it wasn't. There are cases where jewellery for the new paramour, as one of the cases refers to the new partner, was added back, another where it isn't. So that's part of the reality testing, the uncertainty of litigation. But it's very important that clients understand that reasonable living, even if one of the parties has cleaned the bank account out, but the net result of that is when you get the bank statements, you see purchases at Woolies, at petrol stations, at Big W, at office works, and there are children who are going to school. I don't think the courts are at all interested in arguments about adding back what actually, sure, it might have been a premature unilateral distribution of matrimonial funds, but how is it used? And I'll include for you a decision a few years ago now, Justice Murphy, Cowper, K-O-U-P-E-R, Cowper number 3. I always get a little jaded when I see parties, matters have numbers after their case because they obviously like litigating. But in that decision at paragraph 108, Justice Murphy set out 5 questions to ask yourself about adding back or arguing from an add back. And number 2 in that is, sure, now the second question, paragraph 108 is, okay, even if marital property, a joint asset, money was dissipated by one party, usually without the notice of the other, usually, oh, there's nothing left in the bank account. Was the use of that money, can it be classified as reasonable living expenses? And if that's so, His Honour's made it pretty clear that if it can be categorised as reasonable living expenses, then it is not that affront to justice and it will not be added back. His Honour also reminds us, as the full court in Devon did not all that long ago, that adding back is not the only way to approach, this matter of either the reckless, wanton, negligent use of money or the premature distribution. That decision, CalPA, but equally Bevan, the full court decision in Bevan, which was the first full court decision that really grappled with ADVACs and post-Stanford, those decisions remind us that adding back to the pool is not the only way, and the court will certainly be interested in looking at conduct. 7520, is it something instead of adding back, and particularly ADVACs in small pools, that's all you might have left if you're adding back on one side of the ledger. Would it do more justice and equity as between the parties, plural, if the conduct, for want of another word, be dealt with under other 75(2) other factors? Now, back to the CalPA decision, it's useful to note that the Chief Justice, Chief Justice Bryant, approved that approach, the 5 questions, in a decision called Shimazu. Sounds like a disco, I like that one. Shimazu and Tanner, which I'll send to you, but it was Her Honour acting at first instance. But then Justice Strickland, also of the full court, made it plain in a later decision he disagreed with that. All I'm suggesting, as is their wont, and it's lovely when you have the 2 of them arguing in court in front of you and they each want you to pick a side. You're not necessarily that silly. But I would invite you to think about the CalPA 5-step position as a way to, heavens, is it actually worth our while going to court and pursuing this principle when we may not get up, and when that might be the difference between a resolution and the parties acting for themselves or with certain assistance from yourselves and litigating. And also think the court will look at conduct. Now, Erin's included in her memo a number of cases in the memo where the court declined to either add back money or decided it would not be just and equitable to require, for example, one party to sell the house to fund the other. So you've got those different ways the court can approach things. The last thing on the pool I'd like to talk about, and then I'll be handing over very shortly to Jane, is partial property settlements. Just because something is called a partial property or interim property settlement does not mean it can't be argued about. Or let me say that differently. Just because it's called a partial property settlement does not mean it will necessarily, irreducibly and definitely go back into the pool. Section 79 is a once and only power. A decision, again it'll be in my memo, of Gable and Yardley made it clear that even if a party, often, not always, but often the wife receives, $20,000 on the first day of court as a partial property settlement, the court is still entitled, when it comes to the final resolution of the matter, to look at how that money was spent. Now, I always tell my clients in those situations, when they get a partial property, put it in a separate bank account. And so then it's very easy to see withdrawals, Coles, Woolies, reasonable living expenses. And there are certainly plenty of instances when a party has received a partial property settlement and the court has then disregarded that when it comes to calculating the pool for final settlement. And finally, on the issue of chattels, which I know you can have millions of dollars, but then the deal can fall over chattels. I read a memo produced by Tim North of Senior Counsel, used to be Queensland, now of Melbourne, many years ago, where he formed the view that if a party said they didn't have the chattels, or a party said, yes, I'll do my best to hand the chattels over, and subsequently didn't, there was nothing you could do about it. So we know then our contributions is our next step. As I've already alluded to, short relationships with no children, of course the contributions focus will be on the money, who contributed the real property. Medium and long term, when there are children, of course that changes everything. But also here, reality test the client. I've never actually found the case where you'll have conferences. She did nothing. All she did was watch television all day and drink wine. Or he never did anything. Be careful of the absolutes. Quite often when at times the husband says, my wife did nothing, it's a pretty easy cross-examination. So you leave for work at 7 in the morning. Yes, so she took the children to school, and there you go. You've already dispelled the done nothing. A difficult factor under contributions, though, is the canon, is the domestic and family violence. I think the law is too hard in this area. That said, we have a no-fault-based system. You would all know Kennan, the decision of Kennan, and perhaps to a lesser degree the full court decision in Spagnardi. I'll send both of them through, and in particular Spagnardi. Quite often, the prevalence of domestic, family, intimate partner violence is one, of course, that's horrendous. But don't forget that the mere fact of violence and abuse, that's not enough to get a property adjustment in your client's favour or to resist one, depending whose side you're on. There has to be two limbs. Not only does the court find that the violence and the abuse occurred, but did it make the contributions more onerous? Now, I don't know how you prove that. And that's why domestic and family violence doesn't find its way very often in property proceedings. It's an interesting policy debate to be had about that. Where does the pendulum swing between fault, compensation, and properly recognising something that is awful, truly awful when proven on the balance of probability to the courts, but not a policy discussion we can have today. But again, part of the reality testing for your clients is if domestic and family violence is alleged, that's not enough. There's also got to be the more onerous contribution, the demonstration that the contribution was more onerous. And that's very hard to do by virtue of the insidious nature and behind-door nature of violence. But don't forget that Kennan stands for, so don't forget that it stands for more than just domestic and family violence. There's certainly cases where a party's alcoholism was determined to make the other party's contributions more onerous. But the reality is, in a small pool, these are not matters that really help solving the issues. But it's important to keep in mind in a small pool that domestic and family violence on the state of the law, rightly or wrongly, is a very difficult issue to prove. And even if you can prove those two limbs, then very little, very little percentage. Kennan was the high mark. Very little often the courts will say 1%, or I'll just put it into the factor of the contribution. I'm now going to hand over to Jane to tell us what the theme she developed in the Section 75(2) factors, which I think is fair to say can often be critical in small pool matters.
So I wanted to thank Jacoba and James also for having Erin and I here today. So the focus of my research was on the relationship between small asset pools and then the application of 75(2) factors in those small pools. And what emerged, which you might suspect, is that Section 75(2) adjustments do become more critical when the pool is small. I'm going to read a quote from the case of H&T. What then is a proper adjustment under Section 75(2)? The assets of the parties are modest, and so is the superannuation. In some senses, the smaller the asset pool, the more critical the adjustment for other factors beyond contribution may be. So that's definitely the main point to take away, and this is the same also for de facto property settlements. And when making an adjustment, it is the real impact in money terms rather than just the percentage points. So you do need to look at, what the parties will walk away with in terms of cash. So another significant aspect of the case law research that emerged was that a small asset pool in combination with a disparity in earning potential between the parties will generally favour a Section 75(2) adjustment in favour of the party with the lower income. So typically in most of the cases I looked at, the party with the lower income was the wife. So the combination of that small pool with the lower income earning capacity favoured an adjustment based on 75(2) factors. And in Harper and Harper, the judge there stressed that you did have to have the combination of those two things. But in that case, there was a small pool and the wife was taking care of the children, primary care of the children in the future. But he said that there should be no adjustment because the earning capacities there were like relatively equal, so you do need the combination of the two. Disparity in earning income potential and small property pools. And when there is that combination of those two, like there was in Gallo and Gallo, there was adjustment of 21.25% in favour of the wife. But obviously it varies depending on the facts of the case. My research also looked at sort of touching on justice and equity in these small property pools. Like I've said, you need to look at the reality of the parties' financial positions rather than simply percentages. And looking at when there is insufficient funds to distribute to account for the parties' contributions and future factors. When there's just insufficient resources to do that justice, that doesn't mean it's an unjust or inequitable outcome that one party walks away with very little net resources. In fact, in some of the parties, they made an adjustment, quite a large adjustment based on these 75(2) factors, and that meant that one party ended up walking away with most of the realisable assets or the cash assets, and one party walked away with simply superannuation. And the court has held that that is a just and equitable outcome in small property pool cases. So you can look through my memo at some extracts from the cases which sort of support these different conclusions that I've reached. Thanks.
Thank you. The justice and equity, of course, being the last point. Again, the pragmatism. Be careful what your client wishes for. I remain haunted by, very rarely will there be a justice and equity adjustment, but I remain haunted by one that I saw. I wasn't in the matter, so it's not a war story. Some time ago, very small pool. The wife needed 61% to keep the matrimonial home in which she and the children had lived all of their life, children more so. Judge Jarrett's assessment, or federal magistrate as he was then, an assessment on the usual path was 60%. She was to get 60%, but on the justice and equity, he adjusted up to the 61 that she needed to keep the pool, to keep the house. I later learnt that that was too ambitious for the wife in reality financially. She had to sell the house, she had to sell it at a fire sale, and of course because it wasn't provided for under Family Law Acts, the sale, she didn't get any stamp duty relief, rollover relief. And that really brings me to the best thing I think we can do for our clients in small pools is to reality test them. And that assists with the pragmatism then. It's important that clients understand that this Section 79 or de facto equivalent process isn't about what I need. It isn't about what I want, as much as that would be ideal. But I need enough money to buy a new house. Only if the percentages, the adjustment allows for that, will that happen. So particularly, it's fine if there's millions of dollars, fine if there's hundreds of thousands of dollars, but when the pool is finite, I think it's critical for us to help the clients understand it's not about a wish list, it's not about what they think they need financially to get on with the future. It's important that as best you can, you explain the process to them. Indeed, from time to time, I'll take clients over to court. So come with me. Now, it's a luxury that I may have. I know you're all very busy. But part of the reality testing too, when you first see clients or you're working with them, is to help them understand what the alternative is, what the next 2 or 3 years of their life is going to look like if the matter can't be resolved on a pragmatic basis now, as opposed to 2 or 3 years in litigation. I take clients from time to time with me. We sit up the back, we watch, and frankly, they're horrified. I then tell clients, you know, there's one word that doesn't appear in the Family Law Act. It's the F word, and they often think I'm going to swear. Fair. Fair is in the eye of the beholder, but fair doesn't feature. Now, I can tell you I do a lot of mediations, and I hear one room saying, but I'm being fair, why isn't he? And then in the other room, but I'm being fair, why isn't she? Fair is a very subjective notion, and it's important for clients to understand the F word isn't in the Act, and nor is the J word, just. Just isn't in there either. So the reality testing of going forward with small pools, the pragmatism, the moving, assisting the client, moving beyond, at times revenge, at times clients, a relationship breakup, no matter how nasty, our social science tells us that there are stages of grieving and mourning, as there is with loss of a loved one. And sometimes clients are just too raw or it's too soon to try and talk about pragmatic and practical outcomes. And I think while we're not social scientists, that is also part of our job, to try and assist our clients to frankly avoid litigating if they can. Finally, and slightly off the property pool topic, don't forget spouse maintenance. I'm sure you won't. It may be that there's not the property to fight about. It may be that the best that can happen is the house is sold, one party gets the proceeds, the other super, or there be a small split. But many small property cases, one party is leaving with the single most valuable asset, and that's an income. So don't forget spouse maintenance. And I think litigants in person would be more able to navigate many spouse maintenance applications than trying to do everything at large. And of course, the other issue we shouldn't forget is child support agency, the labyrinth that is the CSA, but there's the objection process, the further objection process, which clients can do. It's time consuming, it's laborious, but it's something that they can do. So assist them looking at other paths and avenues. James.
Jacoba, and Jane and Erin, thank you all very much for that. As someone who's not done a huge amount of family law practice, that stuff just kind of blew me away. And I'm sure it blew away some of our attendees too, who I'm sure will have some questions. One question that came through during the presentation, Jacoba, came from one of our colleagues at the Consumer Action Law Centre, who doesn't practice in family law but obviously does credit and debt related matters. I wanted to know about the family courts collectively, their ability to, or their power to determine and change the parties to a loan contract. What jurisdiction or practice is there in family law courts to change the parties to a contract?
It can be done. Certainly you can, and there's cases where I'm no longer party and James is my, God forbid, my partner. Sorry, James.
Wow.
You can certainly have contracts change, but the problem, which is really the nub of the question, is what about when that affects third parties? Then you get into the whole other world of the third-party proceedings and provisions under the Family Law Act, where those parties are entitled to have notice. And ultimately, the small pool one I did on Monday, one of the parties wanted to be released from the mortgage. Well, that's nice. I don't know what the bank's attitude on that's going to be. That's not an issue that I can resolve. It's a very good question, and I hate, it's probably where the question's coming from. We do what we can in this sphere, and then reality kicks in, and in fact the bank won't release the mortgage, or whoever the contract is with equally won't recognise the new person. Family courts have done their job. It's functus officio, and that's why it's then over to consumer action law centres. That's again part of my careful what you wish for, part of the reality testing, and also important not simply to enter into an order that changes legal obligations, be it a mortgage or other form of contract. You've got to find out whether the third parties will actually be okay with it, will honour it, or will insist on their initial legal rights.
Jacoba, at various points in your presentation you talked about a short-term relationship, and one of our questioners wonders if that's a term of art and how you would define kind of a short-term, a medium-term and a long-term relationship, and what bearing that might have.
We used to have a fabulous judge in Queensland, Justice Bell. He's retired now, and Justice Bell and I would often have a debate that had nothing to do with anything in court. About 5 years is the usual. Under 5 years is considered short, but his honour at times would be a scallywag. 5 years, he'd say, isn't that long these days? But 5 years is the general yardstick, if you like, under 5 of a short relationship. And then when you're looking at longer relationships, you're really looking at, the sort of the 15 years on. And long relationships are usually, the hallmark of long relationships is not so much the time, because if it's 25 years or 30 years, it doesn't matter. But it's usually a phase of life. Had the children, children have grown up, moved out, husband and wife then look at each other and go, who are you? But the short under 5 is the usual rule of thumb.
Perfect. Jacoba, one of the comments that you made in the context of talking about the superannuation and whether it was included in the pool was that different judges have different approaches sometimes to that type of thing. On balance, when our clients are looking for a little bit more certainty than it's kind of up to the judge on the day, what should our advice be as to the likelihood of superannuation being included? More
often than not, super will go in, I think is the case. It is an asset, and Coghlan tells us that. I think the point, though, more from the cases that Erin was referring to is, should there be a split? We've got them, and she's nodding her head here. So the issue, it should properly go in. I mean, there's a whole other world. I know we've got some Townsville people online about DFRDB, Defence Force pensions, etc. Let's put that aside for another day. But super is property. It should go in the pool. But whether there's a split, of course, anything under $5,000 can't be split. But if the pool is 8,000, the super's 8,000, 9,000, 10,000, it would be questionable whether the court would effect a split on such a small amount.
We've described what we've been talking about, Jacoba, as small pools. Again, is small pool a term of art? What constitutes a small pool?
I think it varies registry to registry. For my Sydney colleagues listening, I imagine a small pool is anything under $5 million. I don't know. And some of the well hills in Melbourne. The Act, some of the rules and Acts have quantities, but each registry seems to have its own practice. Small pool for us in Brisbane, $200,000, $250,000. I'm aware in some registries it's certainly less than that, and some registries it's a little more than that. But we're really talking the house, the mortgage, a couple of cars, and a modest house, and maybe a little bit of superannuation. So I think, what I did on Monday, the pool was just over $200,000. It's a small pool.
One of the other points that you made was around a view that had been expressed, or kind of opposing views, I guess, around negative pools not being justiciable. and I wonder if there's the potential for test litigation in that space.
Well, the parties aren't going to have the money to do it, are they?
Well, which might be the more reason for it
to be done, that's right.
Pro bono to get some guidance.
Look, I take your point on that, because I thought the Federal Magistrate Wilson decision had died, and there's certainly more cases saying the only thing left is the debt, I'm going to divvy it up. That's certainly the preponderance of the authority. But I was surprised in looking at this matter for this topic to find a giant brain such as Justice Aldridge making that observation. To be fair though, there was, he determined for specific items that were negative, he wasn't going to adjust, but overall there seemed to be enough property that there could be a division. But I think that's something I'd certainly, if you had a truly negative pool and you had a judge who said that's not justiciable, I think that's wrong. You will email Jane, who will email me, and we'll talk.
Brilliant. That's exactly the response I was looking for. I think that's, arbitration. Is it affordable and worth the while for clients with small property pools? If so, other than legal aid arbitration, where can we refer our clients?
Other than legal aid, yes. I was only talking to a solicitor exactly yesterday about getting together the list of private solicitors who will be prepared to do the same service. I don't care what any of us are paid. We have to do our job exactly the same as far as I'm concerned, whether I'm doing pro bono, legal aid or private rates. Can we make that a watch this space? Because we're going to have to work out some guidelines. It simply just can't be an opt-in system as far as I'm concerned. But I am aware of a number of solicitors. I can't help the south, I can't help the far north or the north yet of Brisbane. But we are looking at getting a panel of solicitors affordable who will give the financials to them, the parties' financials, and then they'll tailor a fee accordingly. And I hope that that's going to be a significant access to justice process that we as lawyers can offer the wider community.
Terrific, that's very exciting. It is 10:04. We have, I think, well, we have gone a little bit over time. Thank you everyone for tuning in, getting some great feedback coming through in the chat box from several of our participants, Jacoba, Jane and Erin.
And thanks to my students.
Thank you. Thanks.
We'll email around Jacoba's memo and the memos that Jane and Erin presented as well, and hopefully a recording of the webinar, technology willing, and be in touch soon. Thanks for your continuing support, and we'll speak to you soon.
Thank you.